propose to do is simply talk to you for about 45 minutes. And then, as Beth said, we will reserve all our questions. And we can, in addition to that, as we usually do when we have a live video, does someone have their?
For some reason, that seemed to happen when John started. Somehow, John, you're on here twice. I don't know. Let's see if it goes away now. I think
I've been removed from the meeting.
Well, but you're still on the meeting. You must be
still in the
open.
meeting.
Yeah, you're still there, John. We can see and hear you.
Yeah, that was coming from John's mic.
Yes. So John, you have to unmute yourself again. You're muted. Oh, now he left the meeting altogether. He'll be back.
So John's a great attorney, but obviously not in the field of technology.
Well, guilty as charged. Okay, but our communications director is incredibly knowledgeable about this, so she's coming to our rescue again.
He is back on. Let's see. But he's muted.
Right. John, you'll need to turn off your mute button there.
All right, how's that?
Okay. Are you ready to share?
All right, can you hear me now?
We
I
can.
can hear you now, John.
All right, excellent, excellent. Laura, are you ready for me to take over?
Just hold on just a minute, John. All right, there we are, ladies and gentlemen. We're full screen. And you will probably be grateful that all you're going to see for a while is the screen. So let me give you a little background on this. First of all, you should have already received, and if you did, no problem. It'll be available after the presentation. And that is the TREC's new revised and amended. Some of them are supplemental forms. John will speak to those in the course of this PowerPoints, but that is not part of the PowerPoints. Those are forms that will be very helpful to you to understanding what John has to say as we go along. I won't take a lot of time to introduce John Leone. Many of you, he's been a friend and an advisor to you, and we're very fortunate to have this relationship with JBGoodwin for, in John's case, more than 30 years, and in our case, the last, let me see, almost going on 10 years now since Mr. Leone joined us. John Leone is what's known as a lawyer's lawyer. He really has some of the more remarkable, John's too modest to say this, but since you let me speak, I'm going to say it, some of the more remarkable certifications and specifications of any real estate lawyer in the state, including having held the state bar real estate specialist certification since 1984, the first year the state bar granted that. And I'm pleased that you are the first to whom we can publicly announce John Leone is now one of only 49 lawyers in the state to hold the designation of a property owners association law specialist, which is both law and psychotherapy at its best and worst. So keep that in mind when you have people who are facing challenges with their HOA. Now, as we move forward, I'm going to turn this over to John, and I will just make my best effort to keep up with him as we move through the PowerPoints. Thank you, John.
Okay, well, thank you, Laura. Obviously, business is just booming in Central Texas. It's absolutely amazing how busy we've been, and there are people moving in from all over the country to Central Texas. We get calls every day from people trying to escape California, Illinois, the East, some of those states up there. So very, very busy. In fact, Sunday afternoon, January 3rd, I drove by the I-30 toll road and Harold Green Road. The Tesla plant, they were working on Sunday right after New Year's. I counted 15 construction cranes. they are going gangbusters out there. So, once they get that done, there's going to be a huge demand for things. So keep that in mind. We are very, very busy. There's a lot going on. And I want to talk to you a little bit about the changes to the TREC contracts. They've put out a draft at this point. They anticipate putting out the final contract sometime in February for mandatory use April 1st. So, and when they do that, it's very unusual they'll make any additional changes to it. But I will keep you posted if they happen to make changes prior to the contract coming out for use in February. So some of the changes they made are extremely exciting. At least they're exciting to a real estate lawyer. But what I want to do is go through those and let you know there are a couple of changes they made that are going to be very, very difficult to understand and keep up with. And you're going to have to read these changes more than once to understand it. It took me a while to try to figure out what was going on. But anyway, we're talking about the 1 to 4 family residential contract and the changes in that. And those changes in that 1 to 4 family contract also apply to the condominium contract, the farm and ranch contract, and to a lesser extent, the unimproved contract, except where they talk about fixtures and so on. So with that, I want to get to the contract and talk about some of the changes they've made. The first thing they've made that's really kind of interesting is they've added to the definition of accessories in paragraph 2C. Now, the contracts, the seller is selling the land, the improvements, and the accessories. And they've been adding to that list of accessories over the years as technology has grown and various other things have happened. So what they've now done is to say that accessories now includes security systems that are not fixtures. Now that's a real change because we've always known that, the land sells, fixtures stay, non-fixtures go. Well, in this case, they have now designated specifically the security systems are not fixtures. And they go on to talk about the controls include the seller's transferable rights to the software and applications used to access and control improvements, or accessories, and the hardware used solely to control the improvements or accessories. Now, that covers all these newfangled doorknobs that people can get on their phone and their app, and they can lock their door, they unlock their door, and they're now saying that conveys with the property. Now, they define smart devices later on in paragraph 10C, and we'll talk about that a little bit more. But for now, accessories includes, security systems that are not permanently affixed to the property. They now convey. I presume if you have a seller that doesn't want that to happen before he lists the property, he needs to go through there, disconnect those, take those, and put back our standard, which I'm used to, is a lock and key and a knob. So, but keep that in mind because the contracts will now say that those security systems convey with the property. Paragraph 4, they've also changed rather dramatically. Paragraph 4 used to talk about the license holder disclosure. They took that totally out of paragraph 4. They moved that to paragraph 8. And now they've made a new paragraph 4 with a lot of changes to it. It talks about leases, and they have now designated in this contract 3 different types of leases that need to be dealt with on the sale of property. One is a standard residential lease, and that's been in the contract. And, it says, basically a residential lease. If someone is living in the house and there's now a new addendum that has to be attached if there's a residential lease. And we'll talk about that when we get to the addendum. But, if there are residential leases, it needs to be noticed. And it doesn't say anything about written residential leases. Texas is very lax with oral leases, month-to-month leases. So I think the term residential lease will apply to both written leases and oral leases, month-to-month leases. And like I said, we'll talk about that more when we get to the addendum because there are some specific Texas laws that are going to play into that. And that is, an oral lease cannot be terminated just by saying, hey, dudes, you got to get out of the property. That doesn't work. It's a month-to-month, and you've got to give 30 days written notice to terminate an oral lease. So that may have an effect later on when we talk about that addendum. They've added fixture leases and leases of natural resources. So fixture leases, a lot of people now with their property, they're signing leases with companies to provide solar panels, propane tanks, water softeners, security systems, and perhaps another host of other technological things that they sign a lease for, which means that that third party company owns those fixtures. And, the seller is going to have to identify what those are. I mean, there's all sorts of stories. I remember one case we were involved in particular. The seller had solar panels on the house. It was never discussed in the contract. Did they own it? Did they not own it? Was it leased? It just went by the wayside. The buyer closed, goes in, and all of a sudden next week, the company comes out and takes the solar panels off the roof. And if you know anything about solar panels, that left about 600 holes in the roof. They had every right to do so because the lease they signed with the seller said, if there's a transfer of property, we're entitled to come out and get our fixtures. And that's exactly what they did. They came and got their fixtures. So if you're dealing with those items, a water softener, solar panels, security systems, propane tanks, the seller has to know if they own it or they're just leasing it. And I hate to say it, but I wouldn't be surprised if some sellers have no clue if they own the propane tank or they're leasing a propane tank. So you're going to have to get a little bit specific about that, and they're going to have to do some research. They've also added leases of natural resources. Now, that's new because we used to have a separate oil and gas addendum. So there's now a new addendum for leases of natural resources, which covers not only oil and gas and minerals, but it covers water, wind, and any other natural resource. We're seeing a lot more wind turbines being placed on people's property, even if it's their homestead, even though it may not be a large tract of land. They can put a wind turbine on that and lease it and put it into the grid. So they're going to have to identify any natural resource leases that they have and deal with it. Now, paragraph 4 also goes under C, a seller has delivered a copy of all the natural resource leases. Again, I mean, a lot of sellers have maintained mineral and oil and gas rights. They don't know it. They don't know where the actual lease is because it's kind of been passed down. But this says they have got to deliver a copy of all leases. So they're going to have to find that. And admittedly, all oil and gas leases are filed of record if they're enforceable. So when you get your title commitment, that'll be on there.
John?
Yes.
I hate to interrupt you. Are the slides supposed to be progressing, Laura? We've got questions in the chat room that it's still on the first slide.
John hasn't finished this slide yet.
Okay. All right. Thank you.
As soon as he does.
Well, I think we may have finished this slide, Laura.
Perfect.
All right. Thank you.
Yeah, I'm talking about paragraph 4 now, so we may be 2 slides ahead.
Okay. Now, our next one, John, is our 1 to 4 residential resale contract. Paragraph 5.
That's what I'm talking about now, but we're now on paragraph 4 of that dealing with leases. There's a separate PowerPoint for that.
Okay.
And paragraph 4 again goes on to say that the seller has got to deliver those leases. If he doesn't, the buyer has a right to get out of the contract anytime he wants if those leases have not been delivered. So it's another provision in there that may allow the buyer to walk if he has not gotten those leases. So you're going to have to be on top of your sellers to get sure that they provide residential leases, fixture leases, and natural resource leases. Are our slides not progressing?
We're now to paragraph 5, John. Earnest money and termination of.
Yep, that's where we are. And this is the most exciting change. I'm sorry to get excited about it, but I grew up going through law school all this time, and they always drilled into our head that if there's an option to terminate, it's a separate independent contract that requires separate independent consideration. And that's why there was always paragraph 23 back there that said time is the essence for this paragraph, and if If you want the termination option, you got to pay a separate fee. So what they've done now, and this is kind of interesting, they have combined the earnest money and termination option in one paragraph. Now, I think this is going to create some problems. If you remember under the old contract, a lot of times the buyer would submit their earnest money as well as their option fee to the title company. Well, the title company was under no obligation to get that to the seller, and that's contrary to what the contract said. The option fee was supposed to go to the seller. So in a way, they've made it easier. They have now combined earnest money and termination option fee in the same paragraph. And the first paragraph A says, you deliver the funds within 3 days, and the option money is, the earnest money is X dollars, and the option money is X. They go on to say that the buyer can get that to the title company or the escrow officer in one check. They can combine it now, which will make it somewhat easier. I don't know if title companies are going to want that extra burden, but now it can be one check. It can be one check or two checks. I presume if you've got $3,000 earnest money and a $200 option fee, it's a whole lot easier for the buyer to write a check for $3,200 and get it to the title company. That will now be permissible under these new contracts. Keep in mind, that's not in effect yet. If you're still dealing with the old contract, that option money has to be delivered to the seller until the new contracts are in use. So keep that in mind. You can't now deliver both option and termination, the option and earnest money in one check to the title company. That won't happen until the new contracts are out. And they've added a lot more language in this, which is in a way is very, very helpful, because they now define what happens if you don't get the earnest money there in a timely manner. It says the seller has the options under paragraph 15. He can either terminate the contract, he can file suit. He's got those options in paragraph 15, which are for the default of the buyer if he doesn't deliver the earnest money. Now, the other thing that's interesting, and I've always talked about this, but it now makes it very, very clear that if the contract is submitted and the earnest money is not delivered in 3 days, the seller has got to make an option. He can't sit back and do nothing and then later say, okay, I'm not going to accept it, because the contract makes it very clear that the buyer is in default if he doesn't submit the earnest money within 3 days. But if the seller doesn't do anything, the buyer, the seller's got to make an option before the earnest money is delivered. So what that means is if it's the 5th day, the seller hasn't made an option to say, hey, buyer, you're in default. If the buyer then delivers the earnest money, the seller loses the right to terminate the contract. So, and basically, if the buyer is in default, if he doesn't deliver the earnest money in the correct time, but that default is waived if he delivers it thereafter, and the seller hasn't opted to terminate the contract. So again, that's something we'd always talked about, but you don't want to take that chance with your buyers. They need to get it there within 3 days. But if they don't get it there in 4 days or 5 days, and the seller has not opted to do something under the contract, it saves the buyer basically. So that's good to know. They've also gone to say, as far as the termination option, that you've got to give notice of the termination by 5:00 p.m. local time where the property is located. Now, when you're talking about, and how do this all gets into the question, how do you count days? If you get the contract today, the first day, today is not the first day of your 3-day period. It starts the next day. So if you get a contract signed and submitted, day 1 is tomorrow, and then you go day 2, day 3. So you've got to keep that in mind. And if you're going to terminate it by 5:00 where the property is located, which means if your buyer is in California, he can't wait till 5:00 California time on the 3rd day to terminate. If that's what he chooses, he's got to do it by 3 p.m. California time. Otherwise, he's waived his right. Now, it's always been acceptable if a time is not put forth to do some action, like this now says 5 p.m. If it didn't say that, it would always be considered midnight. If you have 3 days to do something, the contract doesn't specify a time period in that 3 days, you have till midnight to do it. You go to 12:01, you waived your right. So, but now they've gotten very specific and said by 5 o'clock. And that notice has to be delivered by then to the other party to exercise your option. What they've also done is under this earnest money and termination option, we always talked about paragraph 23 was one of the few places in the contract where it said time is of the essence. They have now added that to this entire paragraph. So now time is of the essence for both earnest money and the termination option and the time period set forth in there. And as we've said before, what does time is of the essence mean? It means if you don't exercise your right by that time, you lose it. It's just plain and simple. You can't say, oh, I had a headache, I thought I'd do it tomorrow morning. That won't do it. Time is of the essence mean if you've got to do something by 5 o'clock on Friday, you have to do it before 5 o'clock on Friday, otherwise you've waived your right. So they've added that time is of the essence. Now, any of you that deal with commercial contracts, you know that every commercial contract has time is of the essence in it to make sure that people comply and abide by the time periods in there. I think they're going to start getting to that in this case with residential contracts as well, because it just makes sense. I mean, I remember trying cases where the closing date was a certain date and the seller would say, I'm terminate the contract because you didn't close. But if the buyer went to the title company and wanted to close 2 or 3 days later, the contract wasn't time of the essence for that. So the courts would usually allow that. You know, just because there was a small delay, the seller didn't have the right to just terminate. But now that these provisions are starting to come in there with time is of the essence, you have got to comply with those time periods very, very specifically. All right, Laura, we need to go to the next slide, which is kind of interesting. I mean, I'm an old dinosaur. When I was in law school, I still had wet copiers. They didn't even have Xerox machines. They're all wet copiers, which meant that after 6 or 9 months, what you copied would just fade away off the paper. So you couldn't keep anything. So what they've done now is they have added in paragraph 10 the definition of smart devices. They've defined a smart device is a device that connects to the internet to enable remote use, monitoring, and management of the property, items identified in the non-realty items addendum, or items in a fixture lease assigned to the buyer. And at the time the seller delivers possession of the property to the buyer, the seller must deliver to the buyer all written information containing access codes, usernames, passwords, and applications. The buyer needs to operate those controls. And it goes on to say the seller has got to terminate and remove all access and connections to the improvements and accessories from any of seller's personal devices. Now, I don't know how you would enforce that, but it, basically simply saying this says you've got those smart devices on your home, they convey. It means you've got to give them all the paperwork on it, your passcodes, anything else, username, anything else that has to do with any software applications you may have has to go to the buyer. And then you are supposed to delete from your own phone as seller any of those codes or passwords. I don't know how you can enforce that. Now, I am presuming that if a buyer gets conveyed these items, he can probably go in and change the passcodes and usernames, which I think is obviously the smart thing to do. But if he doesn't, I presume he runs the risk that the seller hasn't done it. The seller can open up the buyer's house anytime he wants to if he had deleted it from his devices. So that's kind of an interesting provision they put in there, and I'm not too sure exactly how that's going to work. I don't know how, if you're a buyer, you can ask for proof from the seller that, hey, did you really eliminate your passcodes and usernames and get the app out of your phone? So that'll be interesting to see how that plays out. So once we open this up to questions, if someone's got a better idea about how these things work than I do, I appreciate a little input, because I just foresee that being a problem when the seller is supposed to do that. And there's no real way to know if he did or enforce it. So But they have defined smart devices to include all, and that includes the software, applications, anything that he's got to do to operate that. So, it's going to put a pretty big burden on the seller to accumulate that stuff and get it over to it. That's why I said initially, if the seller doesn't want to do that, he's got to take those devices out of the house before he lists it, go back to the standard way, and just move on. I did skip paragraph 8 briefly, and there's really not a slide on that, but what they did is they took that paragraph 4 about the disclosure of brokerage for buyer or seller and put it in paragraph 8. So, all right, paragraph 18 of the contract dealing with escrow agents. They made a pretty good change here, in all honesty. First of all, it says the escrow agent may require any disbursement made to be good funds before the escrow agent has to do anything. Now, obviously, if a check is given to the title companies don't like checks anymore, but that check is not good till it clears the bank and the funds are delivered. What I learned when I was doing a lot of closing is cashier's checks aren't necessarily good funds. If a buyer goes to a close, I had this happen, a buyer went to the closing, delivered a cashier's check, left, then he contacted his bank to cancel it, and he was able to do that. So it's really interesting that it's kind of a misconception out there about cashier's checks or money orders is they're not necessarily good funds. There are ways that you can stop payment on those after the fact, after you've given them to a third party. I said, I never knew that was possible till it happened. So good funds kind of protects the title company. They are not required to do anything until they know they have good funds in their account. Now, the change they made that's good is in paragraph 18B. The title company's always been authorized to make expenses out of the earnest money if bills were submitted to the title company. And it was always a problem when the buyer, say, for example, the buyer was obligated to get a survey, and the buyer gets the surveyor sends the bill to the title company, the buyer then defaults, signs the earnest money over to the seller. What happens to the surveyor's bill? I mean, title companies, always wanted to pay it out of the earnest money that the seller was to get. So the change they made is that authorized expenses now mean that we're authorized, it only applies to the party that was responsible for that bill that comes out of the earnest money if they were supposed to get the earnest money. So in the example I just gave, the seller would get the full amount of the earnest money, even though there's a surveyor's bill, because the contract now specifies that the payment for bills only goes to the cost incurred under the contract by that party, either buyer or seller. Like I said, that's a good change. So that's good. All right, 2 more changes on, before I get into the addendums, and that's very interesting. The one thing they did add on page 10 of the contract is they now put a blank in for team name. So I think that's obviously a good change. There was always a question about, I always see contracts where the associate's name was just a team name. You never knew who the agent was. So now they've added a separate blank for team name. All right, paragraph 22, they've added 2 addendum. They're brand new addendums, and one addendum deals with residential leases, and the other addendum deals with fixed leases. So I'm going to take a look at each of those, and we're going to kind of go through it. Again, to me, this residential lease addendum is pretty confusing. It says the seller, and it carries through the provision in the contract before about the seller cannot execute a new residential lease or amend an existing one without the buyer's written consent after there's been a contract. So if there are existing leases, there are 2 options. Option A is termination of residential leases, or B is assignment of leases. So if your buyer wants to buy and there's a lease and he checks termination of residential leases, that means he doesn't need to close until the seller has terminated those leases. Now, the transfer of title to property does not affect existing leases. The leases convey with the property are unenforceable. So If you've got a buyer that wants to terminate residential leases, that seller's got to get on the stick and figure out how or if he can even do that. And like I said, I think that includes ORA leases. So if there is an ORA lease, he can't terminate that until he's given a minimum 30 days notice to terminate the month-to-month ORA lease. If it's a 1-year lease and he's 3 months into it, you can't force a tenant to cancel the lease. He's either got to buy him out or get the buyer to buy it with an assignment of that lease. And they put in big, bold print, notice, this paragraph will not amend or terminate any existing leases, which is true. So if you've got a seller with leases and you've got a buyer that doesn't want those leases, there's got to be some negotiation on how that's going to be done. And like I said, there could be a fair amount of time involved in doing that. So you've got to make sure that that's dealt with early on, because it can be a minimum 30 days. And there's even some case law that says if it's a month-to-month lease and you're at the 15th of the month, you need to give one full term, which means if it's the 15th of March, you'd have to give notice to terminate the month-to-month for the month of April, which means it's 45 days. So, you know, it involves some time periods in there, and the seller needs to know what he's going to do and how he can do it. And the other option, obviously the easiest option, is the buyer buys it subject to an assignment of the lease. And again, that goes through that the lease has to be given to the buyer. And if the buyer doesn't get the lease, he has a right to terminate the contract until he gets the leases. And then the seller is required to make a bunch of affirmative statements, which would survive closing and would be enforceable. And that is, it's in paragraph B3, that according to the seller's knowledge, the residential lease is in full force and effect. No tenant is in default. No tenant has prepaid any rent. No tenant is entitled to any offset against rent. There are no outstanding tenant claims. And that can just be a simple little letter saying, hey, I think you need to go out here and repair some things. That's technically, you know, a tenant dispute. There are no other agreements or options. I mean, we've run into that all the time where there's a lease that doesn't say it in it, but all of a sudden, come closing, the tenant says, oh, I got this option to buy, and it's on a separate piece of paper. It may be handwritten, and it may not be what a lawyer would draft, but if it's a written document signed and dated, it's technically enforceable. And we've had a lot of tenants show up with, oh, I got this right to close, and I got a first right of refusal. I've got the first option to buy. So you need to find out from your seller if there are any of those issues out there. Because like I said, it can really create a problem as far as delaying closing and creating problems. Okay, we're going to go on to the natural fixture leases. That's the second addendum, and these are required to be used. If there are residential leases, you have to use the addendum. If there are fixture leases, you've got to use the fixture addendum. And it's pretty straightforward on the fixture. Excuse me. You know, and they go through and specify what it is. It could be solar panels, propane tanks, water softeners, security systems, and a blank for something else. And this is what's interesting. It says the buyer shall assume and seller shall assign to the buyer the fixture leases except the following. And then in paragraph A2, the buyer's got a choice. Prior to closing, seller will or will not remove the leased fixtures. So, you know, if a house has solar panels and the buyer doesn't want it, he can check that box that says the seller will remove the solar panels or the propane tank or a security system. He's got that option that he can have those removed by the seller if he doesn't want them. And it also has a notice there. Any leased fixture remaining in the property are subject to the rights of the lessor under the fixture lease. That means it's the third party. You have a solar panel company that came out and put solar panels on a house. it is still subject to that lease. That's why it is so important that the seller has to get that lease to the buyer so he knows what rights that third party has in referencing the whatever the fixture is, to know if it can be taken, not taken, if he can assume the lease. You know, some of those leases may not be assumable, or they may be assumable with a fair amount of money. That's why in paragraph A1 it says, if it's going to be assumed, buyer shall pay the first X dollars of any cost necessary to receive an assignment of fixture. I presume specifically on, you know, solar panels, propane, all that, that there will be a cost for these companies. Just like when you buy a condominium, there's a condominium fee charged at closing. So there will be a fee if the buyer is going to assume that fixture lease. You need to find out how much it is and who's going to pay it, because I wouldn't be surprised if it could be fairly substantial in some circumstances. So this fixture lease is, again, it's got a provision there that said if they haven't been delivered to the buyer, buyer's got the right to terminate until he gets them, basically. So keep in mind that the seller has got to make sure those documents are given over to him. Otherwise, you're just giving the buyer options to get out of that lease whenever or however they want to. So that pretty much covers the changes to the contract. Like I said, they're not overly substantial. There are some really interesting ones. Like I said, interesting to me. I don't know if you find them interesting, but anyway, and we'll know more. I don't think they're going to change them. But when the final contracts come out, we'll know. It's supposed to be in February sometime. And if so, at least you got a heads up on what you need to look at and what's there. So, you know, does anybody have any questions about
Okay, John, hold on just a minute. Ladies and gentlemen, you're witnessing a miracle, which is that the trial lawyers here got through ahead of schedule, even though we actually started about 10 minutes late. So I would like to propose, John, because we do have 7 minutes remaining before we promise we turn it over for Q&A, that we try and race through our 8 additional points, if you don't mind. Beth, is that okay with you?
Oh, yeah, I think we should, because I think there's some important things that we need to talk about.
John, we're going to have to be short-winded. This is 1 minute per slide, but the reason we chose, John, chose these is because as much as we love having you pay us all kinds of money to defend you when you get sued, these are things that if you can walk out of this session today mastering these 8 points, and although conceptually some of these are complicated, you don't need to learn all the law today. You just need to know this is something that can get me and my clients in trouble. And if you'll just be sensitized to that, and you're going to have this whole recording and the PowerPoints, and it's worth writing down these 8 points, because these are what get agents, brokers, and their clients sued. Now, here are all the questions. Again, you'll get this at the end. And some of them are kind of tangentially what you do in real estate. They're not directly. And this includes property management and a little commercial. So here's the first one. Real quick, John, I'll take this one. Right now, when we started in March, actually April 3rd was the first day the Texas Supreme Court suspended all residential evictions. April 3rd of 2020, and mortgage foreclosures, which more than 80% of those are federally regulated programs, So February 1 is the new date before which any client that tries to evict a landlord or a property owner that tries to evict a residential tenant can get in big trouble, including, if they're deliberate about it, being forced by the courts to sanctions, which can include, they defy a court order, criminal. So don't tell a client to start gearing up for eviction. Can you file for a proceeding? Yes. Can you evict? Absolutely not. And I suspect, just as we learned 2 days before the end of the year, that our mayor, our county judge, and this is county by county, community by community, was going to expand it again. I am very doubtful that February 1 will be a date this is all lifted.
Yeah, and Laura,
And with the developments in the federal government, I think that's probably true. Mortgage foreclosure, in case you don't understand, has a companion eviction. Somebody getting foreclosed on may need to also be evicted. Well, if you can't evict them, what's the point in the mortgage foreclosure? So go ahead, John.
Yeah, I need to just point out that the city of Austin has adopted a much more stringent requirement than the state for no evictions prior to February 1st. What Mayor Adler and the council did, it's really kind of interesting. They said you cannot send a notice to vacate. So if you're in the city of Austin, you cannot even send the notice to vacate preparatory to filing your eviction. And it not only applies to residential properties, it also applies to certain commercial tenants like childcare businesses, live music venues, arts venues, restaurants, and bars. So if you've got a landlord who's rented to a business, a bar, a restaurant, you better hope it's not in the city of Austin, because he can't even give a notice to vacate to those types of commercial businesses until all this is over with.
That's a very good point, John. And I just want to say to all of you, even if you feel like because you're a property manager, you knew this area well, nobody knows this area well anymore because it's changing every couple of weeks. So don't, and also on top of that, this is precinct by precinct. John's absolutely right what he just said. Plus, justices of the peace, which are constitutional courts in Texas, even if they're not licensed attorneys, they're setting their own rules. And some of them are just not taking any commercial or residential eviction. Why? Because they can, because they're elected officials. Sorry to interrupt, John.
Oh, that's fine. That's fine. And as far as commercial foreclosures go, again, we haven't really seen any of those. And by the way, you can still have a residential foreclosure if it fits under those few areas where there's a safety issue, a threat of physical harm, criminal activity or damage that is being inflicted on the property. So you can still foreclose if there are those issues about criminal activity or physical abuse. But anything else right now is, in fact, I got a call from Volunteer Legal Services last week. They are looking to line up attorneys to volunteer their services when the evictions hit to represent tenants free, because there's going to be a huge glut of those. And they're trying to get attorneys to volunteer their time to assist those people. So it'll be interesting to see what happens. As well as,
John, if I may, we are gearing up right now. Bankruptcy is something that you should not treat in a trifling manner. We anticipate, most legal authorities anticipate, there will be a huge wave of bankruptcies, just like what John's talking about with getting lawyers to these indigent tenants. There will also be many, both commercial and residential tenants, that file for bankruptcy. You cannot take action against someone who's invoked the authority of the bankruptcy court without the authority of the bankruptcy trustee. So tell your tenants that is when they need to go get legal help immediately. And particularly, we now have, for the first time in our history, the juxtaposition of all these unique suspensions with the traditional bankruptcy court jurisdiction. And that's complicated. So that this is not a course today on bankruptcy and eviction. This is a course on everybody. When you hear one of those two words plus foreclosure, you tell them to go get some help. Okay, John, you always have some wise thoughts about this part of commercial foreclosure.
It's amazing to me, you can only foreclose in Texas, whether it's residential, commercial, whatever, the first Tuesday of each month. In order to do so, you've got to give a written notice, certified mail, return receipt request at least 21 days in advance of the first Tuesday of each month. And that day does not slide. It's the first Tuesday, even if it's holidays. I foreclosed on somebody once in Bastrop on New Year's Day. Now, I guess that's kind of being a bit of a Grinch, but the first Tuesday of the month was New Year's Day. It doesn't stop the foreclosures. You can still go to the courthouse steps and do your foreclosure. But it's amazing to me how many times people wait till the Monday before that Tuesday to come in and see if you can help them. That's why I say don't have your clients stick their head in the sand. This applies to residential and commercial. I can tell you that unless it's a third-party hard lender, they don't want the property. They will do anything to avoid it. I had a situation, we've been working on it, and, the client was at a building and a restaurant, and obviously they've been closed down. We've gotten the lender to waive 6 months of payments and add it on to the end of the loan. And that's the thing they need to do. They need to be affirmative, take some action, and negotiate with them. Banks don't want all this property back. There could very well be a glut of commercial space here very, very soon. You know how many businesses have realized that, hey, we don't need a fancy office space to run our business. People can work remotely from home, and we are just as successful that way as not. I think we found that out at the Fowler law firm when, we for 6 weeks didn't come into work, and we didn't miss a beat. We were as busy as ever. We had client meetings by Zoom and everything, and transfer documents. You can do notaries virtually now. So, I think a lot of office space is going to be available, and it's going to be interesting to see what that does. I think there will be a chance to perhaps buy commercial property, rent commercial property at a lower rate than has been demanded recently. So we'll know when all this pans out here, depending on what happens. But
John, give us a real quick talk about rollback tax liability. Now let's roar through the rest of it.
All right. Let me, property that has an ag exemption is taxed at a very minimal rate. When that property sells, if the use of that property changes, they can assess rollback taxes going back now 3 years. Used to be they could go back 5 years. Now they can only go back 3 years. That's a substantial amount of money. I have some people come into my office. The family farm has been for decades, centuries, and they sold the property. They didn't go to an attorney. They didn't have anybody check the contract, and as a result, the sellers were responsible for rollback taxes. So what they do? They sell to a home developer who goes in, changes the use. County went back 3 years and submitted the seller a bill for $250,000 in rollback taxes. That is a negotiable item in those contracts. So the seller needs to be aware that, if he doesn't make the buyer pay it, or it's not added into the price of the home, he could be hit with a substantial amount of money. Now, ag exemptions don't just apply to animals. It applies to trees and crops. So, I had a client that, he just went out and planted, 50 pine trees, and he got an ag exemption, and he just kept planting some pine trees. That's all it takes to get an ag exemption. And like I said, the taxes are 1/100th what it would be as opposed to regular taxes. So rollback taxes are a major, and it's not just commercial transactions. There's a lot of people, especially out like Palmer Lane, these areas, these arteries that are going out from Austin. People are selling the old homestead, and they need to get advice because they can really be hit with some bad problems when these properties are sold, and rollback taxes is one of them.
Okay, thank you, John. Now the next one I'm going to skip because John just talked about it, so we're not going to confuse you again. On intermediaries, this is coming up increasingly, and I think a brokerage like JBGoodwin, which is well respected, many of your agents are very mature, everybody loves you, and they start sweet talking you and represent both sides of the deal. And we're seeing more and more after the deal doesn't work out, how one or both parties turn on the brokerage, and the brokerage, not with JBGoodwin, but with other clients, didn't understand that with an intermediary agreement, you have got to either have a broker that largely performs no services. If the broker is going to represent both the buyer and the seller and not appoint agents for both buyer and seller within the brokers, the broker really cannot do much more than pass paper back and forth. And many people, because they just love you so much, they'll sign anything in the beginning because they want JBGoodwin to be their agent for everything. But at the end, if one or both parties are not happy with the transaction, this is grievable misconduct, both by the broker and the agents. So I teach, when I teach broker responsibility, we spend almost an hour on this. If you are in a situation where both sides of the transaction are agents associated with the same broker, you need to slow down, take a deep breath, and be sure you understand. And the best way to understand is go right to the link you've got here, which is the TREC Broker Responsibility book, and do exactly what it says. And what it says is counterintuitive to a full-service brokerage like JBGoodwin, because when the agents and the broker are all in the same brokerage, the amount of service, opinion, evaluation you can give is very, very limited. So word to the wise on that one. The I word, intermediary, beware. Now, this one, which we teach a whole course, I think we're set to teach this up at Austin Board of Realtors this year sometime, is how residential leases differ from commercial leases. And let me just say, if you're a residential agent, you need to go get some help from an agent that does commercial leases, because one's a zebra and the other's a giraffe. And now we're getting something that I find very complicated, which is you get these condominiums that are mixed use and commercial on the first level, retail, and then on the second level, there'll be condominiums, residential condominiums. You really need to keep your wits about you. Some of these developers, they make big mistakes on the description of the tract, and they confuse and merge commercial rights with residential rights. And if you're an agent showing these properties, you've got to be sure you're using. You can't just rely on the title company, because these mistakes get carried forward over and over again. But John, why don't you talk to us? If this sounds like commercial, especially if you're selling lakefront property, this comes up all the time.
Easements. All easements are supposed to be listed on your title commitment Schedule B when you get it. Now, there's all sorts of different kinds of easements. We all know about your utility easements, and usually in a subdivision, they're down the side of the lot or the back of the lot, and and virtually every lot has them. That's not a big deal. I had a case the other day when someone came to me, they bought a piece of property, and there's a pipeline easement right down the middle of the property. They knew about it. They didn't think it would be a big deal. And when they went to buy their house, went to build their house, of course, you can't build on top of a pipeline easement. So, if there are things like that, and we were able to get the pipeline company to move the easement to the edge of the property. They didn't have a problem with that, but that just shows you the kind of things you can have. Now, I've run into recently, I've seen 2 blanket easements on property. Now, what a blanket easement is that means somebody granted the right to a third-party company to have an easement anywhere on the property they wanted to have it. That means it could be anywhere on the property at the choice of the third-party company. Obviously, blanket easements are absolutely terrible. You cannot sell property with a blanket easement. So keep that in mind. Roadway easements. There are all sorts of potential easements regarding roadways, some by prescription, some by use, some by necessity. Usually the surveyor, if he goes out there, will note on the plat if there is a roadway on the ground. And if there is, he's got to, you got to do some checking, or he does, or the title company does, to find out if it is a recorded easement or not. Normally, a lender will not lend at all if there's not a recorded easement for access to property. It'd be very rare that they would. So we've had situations where, oh, this roadway, we've used it for 30 years. It's not a written easement. No one's going to lend on it. It's just not going to happen. So they've got to get a written roadway easement in place and filed of record. And it depends. Like I say, you see that so much out, especially there's a lot of that out in Jonestown now. Jonestown is expanding so quick. And 25, 30 years ago out in Jonestown, they were not real careful about how they did things. I mean, there's there's some stories about a surveyor who, towards the end of the day, he just decide not to go down to the lake to see where to put that pin. He would just put it where he wanted. But easements are a major issue, and the buyer, if he's got questions about what shows up in his title commitment, he needs to address those. It's not really going to be a problem in a subdivision lot where there's been a plat and so on. Those easements are all on the plat and recorded. But if he's buying a tract of property not in a recorded subdivision, he may have problems with easements, access, etc. All right.
Last point on that, this myth that I am presented with constantly, I'm grandfathered in because someone has access to the lake or to some more desirable tract. That is just a myth. It means nothing. Questions regarding someone, as John said, has an easement by estoppel or an easement of use because they used it over a period of time, which is really more along the lines of continuous adverse possession, which cannot occur if your use was by the permission of the surface landowner. Now, next one, this is the biggie. Many people do not realize when they come to Texas that by code, we don't have a standard building code in Texas about anything. Every city passes its own unique building code, and most of those building codes, and it's city by city, there's nothing uniform. Most of them carry criminal consequences. There are many things that you cannot do unless you are licensed to do them. And a big one that our property owners stumble over, somebody has a door that the locks don't work, somebody has a security system, someone has plumbing or electrical. All those must be done by licensed electricians. When you go 5 years down the road and you have to disclose all work done on a property, if you want to sell it, and you didn't use licensed electricians and plumbers, what you're disclosing is criminal misconduct. And property managers are the worst about this. Many property managers who aren't owners are licensed real estate agents. So do not make that mistake. Master what licenses you have to perform basic repairs. And the biggies are sewer, septic, plumbing, electrical, and security, which means simple locks. Okay. John, you want to address this? This is really a probate question. Let me just say very quickly on this one. If you, we have had realtors set for closing fully aware that the seller is dead. If the seller is dead, you don't just go get, the probate courts. We have wonderful probate courts in Texas. They're streamlined. There's much less expensive and faster than what you see in a lot of states, but it's not like the drive-through at McDonald's. If someone dies, you can't just proceed to sell the property. And I could talk for an hour about that, but the transaction stops. And there are things you need to do. Don't try this one yourself. Don't just do what the title company tells you to do, because you may have placed your seller or your seller's estate in breach. And the same is true of the buyer. So death or incapacity, the person is so ill they can't go over and sign the documents and no power of attorney has been executed. Get help or you will get yourself into a breach where you can get sued. Same thing here, mental illness and incapacity. Anticipate that at the time you take the listing. Don't think because children are telling you what to do that they have any authority at all. Once you know who the record title owner is, you need to take steps, because if someone is clearly incapacitated, and we get this all the time, they bring them over here, and a lot of people move in, elderly people on a lot of prescription medication who may not be that old, they move in and out of lucidity. If they're sundowners, for example, often, if we can get people up here early enough in the day, we administer some questions that we videotape so that angry heirs who didn't want something sold can be defeated later on. But if you're dealing with a child and the record title owner is an elderly parent that doesn't seem to be competent, get help. Don't try to do this yourself. Get probate lawyers and estate planning lawyers that know what they're doing. Because you can get anybody to sign anything, incapacitated or not, and it is not going to hold up in a court of law. And then you're going to get in trouble if you were the one who was the catalyst for that execution. Okay, one more. And John, I'll just take this one. Why are you letting people steal your stuff? If you have, and TREC now allows you to have business names, trade names, team names, you really ought to, and you're think about trademarking and not letting people run off with your stuff. And I'll just say this. If you form a team, the A team, for example, and there are 3 of you in it, you have formed a de facto partnership. We urge people who form teams and want to use a team as a trade name as realtors to let us file for them a simple limited liability company. And within that limited liability company, we guide them towards agreeing if the team doesn't work out, who owns the name, the A team, who owns the website, who owns the domain name, which may be different than JBGoodwin. So think about all that, and also know these team names, you've got to comply strictly with TREC's rules on advertising, and that's confusing. Now, last but not least, and then we're done, John and I, because we love JBGoodwin so much, if you have a need, you call our office and you tell them, either you, the agent, or your client say, JBGoodwin referred me, we will give them a first consultation, limited in length. And I don't mind telling you, I'm proud of this, even if it sounds like I'm bragging. A lot of times they are more than willing to pay us money, especially these people coming from California who got so much money to buy new land and they want to get it right. And about half the time, John and I talk them out of spending money on lawyers. They don't need it because Texas, they've got a great realtor like you, and Texas is more friendly for whatever it is they want to do. And so we just guide them through it, give them some links. And then they think you've got a wonderful referral network, and they think you're trustworthy lawyers. So we love the clients that send us. If they will say a JBGoodwin agent sent us, they will be prioritized in terms of getting there. We try to return every call by the end of the day, COVID or not. We try to hit that standard, but if they say it's JBGoodwin, they're going to get priority treatment. So with that, and forgive me, we did run a little over, but I'm done. And Beth, if you want to route questions to us, fire away, or let everybody go, or whatever.
No, we do. We have a couple of questions, so thank you guys so much. The first question came from Janet Murdoch. It's regarding evictions of tenants during the pandemic, and she has a landlord who has already posted the notice to vacate. The property is in Manor. The tenants have done damage, have not complied with the terms of the lease, including non-payment and late payment of rent. The landlord did file for eviction and directed the tenants to vacate by Friday, January 8th. But the lease does not expire to May 2021. If the landlord proceeds, are there repercussions and penalties due to the pandemic?
John, you want to answer that? It's May.
Yeah. I mean, it's going to be totally up to the JP out there in Manor. I mean, they're not covered by the City of Austin very restrictive one. Although what they have adopted now is if a tenant fills out, it's called a COVID-19 something where he says, let's see, it's called the Declaration under penalty of perjury for the Centers for Disease Control and Prevention temporarily halt to evictions. That if you fill out this affidavit that says, I have used my best efforts to obtain all government assistance, I either make less than $99,000 a year or $198 for a couple, I am unable to pay my rent, I'm using my best efforts. If you fill that out, the court will refer you to mediation or something, will not proceed with the eviction until the parties try to work it out. Now, in this particular case, obviously they don't have the money. If they're not prohibited from evicting unless the tenant adopts this position that, hey, they've been affected by COVID, they can't get the money, et cetera. And if they fill that out, chances are the JP will not evict them and will refer them to some other agency or group to try to work things out. I mean, she needs to proceed with it until the JP says we won't do that.
Okay. Any more, Beth?
Thank you. Yes, there is. And Jenny Lemaban, can you unmute and clarify your question? You said next day as in 12:01 a.m. What was that referring to?
I'm referring to the contract. So example today, they signed it today. So the effective date is January 7, 12:01.
That's correct.
Okay. So, and then I have a follow-up question on termination fee and earnest money. I know they put them together. So before the option money expires 5 p.m. on the third day, 5 p.m. But how about the EMD? Will it expire 5 p.m. or 12 midnight?
Well, I think they've added in there that it's 5 p.m. So, yeah, I mean, I think they've clarified that for a purpose, that 5 p.m. is the time that you can terminate. Now, as far as the 3 days for submitting the money, I don't think it really talks to that, which would mean you'd have till midnight. Let me go back and check real quick. Well, all right, I haven't put my hands on that quite yet. But it's going to be very, very specific in that paragraph as to what applies. If the 5 p.m. only applies to the option money, then the earnest money you would have beyond that. Well, here it is. Yeah, the 5 p.m. only applies to the termination. So as far as the 3 days to deliver the earnest money, you've got 3 days, which would be up till midnight. And it also goes on to say that if the third day is Saturday, Sunday, or a holiday, it slides to the next day.
All right. All right. Thank you.
Okay.
All right, thanks, John. I want to read through the chat room a little bit, and this all goes back to pertaining to smart devices on transferring with the home. The comments include changing passcodes would be no different than rekeying a lock. Reset and introduction of new passcode should happen at closing. It would only make sense for the buyer to change all the passcodes. Prior to delivery, smart devices can be reset to quote unquote factory settings. Would it fall on the provider to ensure the safety of the transfer? And then is the seller able to say that the smart devices do not convey?
Okay, that was a bunch of questions all in one. I mean, I think the seller has the option to not convey the smart devices if he takes them off before he lists it. Once he lists it and the contract comes in, the smart devices convey. So if he doesn't want them to convey and he wants to keep them, he's got to take them out before he gets a contract on it. I don't know, what was the other part of that question?
Would it fall on the provider to ensure the safety of the transfer?
No, I doubt it.
Okay.
I mean, I can't imagine they would have liability if the devices change hands. I think it's up to the buyer and seller to make sure that happens. Let's put it this way. I would never take that case if someone came to me and said, sue the provider because we didn't do it right.
Okay, one more. It says, I am working with a cash buyer who wants to buy a condo and lease it for a couple of years until they're ready to move in. Should I list rental property in 6D? I am reading through HOA docs, but should I list just to be cautious?
Wow. I mean, when you're dealing with condos and renting, so many of them have restrictions on that. I mean, a lot of them won't allow more than 10 or 20% of the units to be rented. So if you're not one of the first ones to rent, they won't let you rent it. And they have the right under the condominium declaration to do that. So, you know, if you've got a buyer, he better figure out in advance if he will be able to rent it or not by checking the condo declaration and probably getting something in writing from the board of directors or the management company as to how they are handling that.
Okay. Just a comment, golden information. You keep us honest, and thank you. The next question is, when does the 1 to 4 family contract take effect? Oh, Leonard,
It's supposed to be mandatory April 1st. And they're supposed to come out with a final draft of it in February.
Leonard, did you want to unmute? Do you have a question? You're still muted.
Thank you. It took me a minute to find the John.
Yes.
Thank you for some great information today. The new contracts class has paragraph 6D objections as something that we need to be paying a bit closer attention to, just in the sense that they are advising not to put intended use to be, you know, residential property here. You would put something like a multifamily unit
Right.
in there. So unless I completely misunderstood it, nothing has really changed there.
No, they haven't made any changes to it, but you're right. I see a lot of contracts where they say residential use, and that is not appropriate to put that in there.
Okay, because typically that's what was always advised before.
Yeah.
In other words,
I don't think that's a good idea. I mean,
Okay.
you know.
so what would be a suggestion on a typical residential purchase?
For example, I'm dealing with a case right now in which the buyer wanted to be able to build 2 houses on a tract of property. So they put in there, you know, does not prohibit the building of 2 separate residences on the property. That would be appropriate, just to make sure. Or multifamily, or, you know, anything like that. But it's presumed that this is residential, and the use is that. I mean, use is going to be governed by the deed restrictions, if any.
Of course.
You've got specific requirements, and you know, you've got to, you know, you might want to specify that, you know, if you want like a 14-car garage, you know, you might put something like that in there to make sure it doesn't violate the restrictions, any other city requirements, and so on. So it's really to put unique situations in there, not something standard like residential.
So essentially just leave it blank if it's for a
Right.
standard residential property offer.
Absolutely.
Okay. And then one other quick question. Are you able to speak to the Digital Millennium Copyright Act, and as it regards to agents using pre-existing photographs and or videos on properties? In other words, somebody had it previously listed and you say, those are great photos, I'm going to use them.
John, would you like me? Have I got a deal for you? We have a whole, you have just asked what is possibly the most complicated, and it's an excellent question because of the serious exposures of agents who do just exactly what you said. So we have coming up, and this was not something we planned for JBGoodwin, but we'd be pleased to present this on the issue of the use of images and the copyright law as it has changed over the years. Because it is not as simple as everyone believes. So that's, you know, the Millennium Act was changed not just for residential images and images in the public domain, but also in relation to music and a number of other digitally based transfers of information. But I would, with all due respect, John, if you want to talk about that one and try and explain it in less than 1 hour, good luck, brother. Because
I can't do that. It's very,
Maybe we
very,
can plan on another session then.
Yeah,
I
but
would love to.
I'll tell you what, if you want to ask a specific, because here's the problem. You've got a whole body of properties that you can drive down the street and take a picture of, right? But then you got a whole body of properties where the images have actually become owned, like a Zillow, a Google, all these digital sellers. And when they publish these images, they start to have rights to these images. And then on top of that, which is not the question you asked, but it is something that we try to help agents to avoid, where an agent uses another entity's, like a Zillow, like a Google, or like another brokerage, uses the images they posted because they are the listing broker. That has been treated, and we've had agents grieve because the means by which the image is characterized, TREC has treated, or a consumer, usually it's an angry competitor, files something, and then we sort it out over at ABOR about a deceptive characterization that agent that used the image was a listing broker. So when you're talking about an agent using an image, and I think that's an excellent talk to have, and we could easily customize the Millennium Act and the U.S. Copyright Act to something specifically. I'd love to do that one, actually, something specifically customized to agents, but it is complicated. That would be a get some help before you go spend a bunch of money printing things or posting things. Because I'll just say this, and am I trying to scare you all? Yes. With digital transfers, unlike you go out and you have a flyer and you hand out that flyer to 50 clients. Well, that's a lot of flyers to hand out. But the ease with which you can hand out that flyer to 50,000 people, if you're a mature agent that's got a decent database, is instantaneous. And guess what, ladies and gentlemen? Every single time that image appears of a house, of somebody else's registered mark, whatever it is that you're using to get people, a Mickey Mouse, whatever it is you put on there, that is a separate violation, carrying a separate fine. We had a client recently that lost his mind. Actually, we were representing the employer of that client, and he went out with an email blast using his prior employer's angry split. Prior employers sent to 50,000 people, "I'm leaving." And he was really just saying, "I'm leaving and I'm going to be at the new blah, blah, blah company." But he used that client's mark to get everybody's attention. He's no longer with that company. That amounted to about $250,000 worth of exposure for one morning's email blast. And we get those kind of awards. Usually we back it down to something smaller and the insurance companies pay up. So any image of a house, if you don't know you have the right to that house, that image, and you also, the same people that used to be your clients and you successfully sold, and ask yourself right now, what in my paperwork that seller signed gives me the right to use that image? And my answer is, I have no idea what gives you the right to use that image, but there sure better be something in there, or you got a big problem if somebody turns on you.
Perhaps we can plan for a later date on that. Thank you for that, all that. That's been valuable information.
Isn't that thrilling? You will be so bored when we get through, but it's very important. Copyright Act is very complicated, but it's very important. The penalty, I always tell people one last thing, and this is true. If John and I got in the car and went over to Wells Fargo with a 6-shooter and held it up, one, banks don't have any money in the window, so we wouldn't get much. But the penalties for violation are huge, and they carry criminal consequences. That's really true. So robbing a bank, violating copyrights in this city, I think a jury and a judge get madder at you for violating copyrights than robbing a bank. So thank you. My little aside there.
We've got a couple of more questions for you guys. Jessica Austin, I'm not sure I understand. Is that a question? It says executed January 6th, day 1, January 7th. Are you still on the call? She may have already left. The next one down says, I'm making a lot of offers and my clients don't get selected to contract. Should I be withdrawing each contract, or is it sufficient to use the email or text that says the seller is working with another buyer?
Well, that's a good question. I mean, if you submit an offer and it's not accepted, I think the buyer ought to withdraw it, or if he wants to leave it out there in case it is. I mean, what you want to avoid is a buyer that submits an offer on a piece of property, it's not accepted, but it's still hanging out there, the seller has it, and then the buyer goes out and contracts with another piece of property, and then the seller then signs that and sends it back as a completed contract. I mean, you've got to avoid the situation where the buyer may be obligated under two contracts. Safe thing to do is to withdraw it or let it hang there for a while, but he can't really go out and contract to buy another piece of property until he knows what's happening with that first outstanding offer.
Okay, thank you. The next one is, are there any potential liabilities to either the listing agent or buyer's agent for ensuring compliance with paragraph 10C or 2 smart devices?
I mean, I don't think so. I mean, it's very, very clear that the seller shall do this, not the agent. So I think it's pretty clear that it's up to the buyer and the seller to state what they want and make sure it's carried out. The agent can facilitate that, but it's not up to the agent to make sure that those things happen. I mean, the agent could never be sued, I don't think, for in case the seller does not delete his passwords and passcodes, that sort of thing. It's not up to the agent to have to do that.
Okay. And Mario and Terry, I'm not sure what this is in reference to. So Terry, if you could unmute, leave blank, or NA, I was taught to leave blank. What exactly are you talking about? Terry's still on the call.
Oh, yeah. Sorry.
Yeah.
I was just always taught in contracts to never leave a blank. And I've had different opinions about that. So in anything that's blank, I was taught to always put in NA. Well, on some of those in DocuSign, it won't even let you put in. So I've been inserting a text, and say NA or $0. There's places in those DocuSign forms that, are challenging to put in NA. That makes sense?
Yeah, it does. The risk you run by leaving something blank is that another party will come in and put something else in there that you won't hold. Well, yeah, any kind of an ink mark, a slash, an NA, a 0, to indicate that, yeah, you're aware that that's there and you don't want to put anything in there.
Great. Thank you.
Yeah.
Tyson just chimed in, said, click on the blank and then hit the space bar. That will change the color and let you type letters in. So there's the hint to solve that in DocuSign. Does anybody else have any questions? We have hit the end of the chat room, guys.
Yeah, I have a question regarding eviction.
Hi,
So-
Janet, go ahead.
Is there any penalty for a landlord who attempts to evict if in fact the tenant doesn't leave or the landlord is told he's not allowed to evict? Because
I'm not aware of any penalty that a court could impose unless the landlord is told once or twice you cannot proceed, and then they still try to do it, and the court could hold them in contempt or something like that. But as far as any sort of a civil penalty for proceeding, no, I think it's just not effective.
Okay, thank you.
Hey, John, this is Tammy.
Yes.
Hey, on the COVID evictions, I just want to make sure is it true that if the rent is $2,475 or above, they can evict? It's just underneath that amount?
Yes, that's in the mayor, the city of Austin. Residential tenant who fails to pay rent and the amount of the rent is less than $2,475.
Okay.
Yes, it doesn't apply to rent more than $2,475.
Thank you.
Anybody else, guys?
John, I have a question about the smart devices. Can you not put under exclusions, under 2D, that those will be removed prior to closing?
Well, yeah, I think you can. Yeah, I mean, I think you could put in there will be removed prior to closing, so it's very clear. But the seller has got to make some indication that they either take it out or will take it out.
Okay. I've had several sellers recently that want to leave their Ring camera and equipment there to monitor the house when it's vacant until it closes. So that would take care of that.
Yeah.
I have one more Pandora's box question.
Oh, good.
Laura, you're going to love it. What we're seeing a lot right now is people are putting in applications for our lease listings and they don't mention any pet or anything. And then we approve them. And then they say, oh, yes, we have a pit bull and it's a emotional support animal. They don't put it up front on the application. So is that in itself a deniable offense?
Well, and that's something we talked about earlier, and there was some talk before COVID that this session of the legislature was going to change and make this clearer about service animals. Now, one thing they have eliminated, and I'm not prepared to talk about all the bills that are pending today in the Texas legislature, with gerbils and Shetland ponies and all that stuff around. But we're still down to dogs that qualify as service animals aren't even treated like a pet.
But not service animals, emotional support. So different, correct?
Different.
Well, because the legislature has not chosen, and if you're wondering why don't they do something, it's because this is such an intensely emotional subject for people who love pets. So the best way to understand this is the law is in complete uncertainty. Now it's clear now that other animals like the gerbil, or was it the hamster that somebody flushed down the airline toilet on Delta? I mean, that kind of stuff. And the airlines that are federally regulated have outlawed or will begin to outlaw all these animals beginning, I believe it's in the second quarter of this year. But strictly Texas residential properties, when you have that come up, whoever is doing the credit checks, they need to get legal help. You know, most things will help you at any time, but I would just have to break that down in terms of what is this animal. The various certifying societies, also you've got guide dogs for the blind, you've got a variety of all dogs that serve PTSD veterans. Then you've got people that fit into a more general category of emotional distress, and they're in that emotional service and support category. So I'll be happy, and again, we don't charge to look into these things. I find it very interesting, actually, but it is often frustrating to property owners and their leasing agents to get hit with something like that, because I would guess most of the time there's very little you're going to be able to do. If the rule was no pets at all, that still doesn't protect you, because a creature a dog being characterized as a service animal, support animal, drop down list of supporting a disability in the tenant, isn't actually a pet. It's entirely different. And because the Americans with Disabilities Act and its companion laws, the Texas Department of, actually it's the licensing and regulation comptrollers, are quite complicated. So, but we'll be happy at any time to give you an opinion about a specific case, and then you can route it in your blog to everyone. So that would be another one. If that happens, take a deep breath, get some help before you make a decision.
Perfect. Thank you.
Thank you. So we've got a lot of thank yous, big thank yous, great information. Does anybody else have any more questions for John and Laura? Okay.
It's so wonderful to see you all. I think this is going to be a much happier year. we're gonna get to the end of this dark tunnel, and y'all, wow, are you in a great place to succeed in 2021? So,
I do have one question.
yes, ma'am.
Okay, sorry. And it goes with Tammy's question. On the other side of the coin, I have clients that are trying to get a lease, and they have emotional support dogs, and I noticed that they didn't list them on the application. What am I supposed to do?
And you're representing the tenant?
Yes.
Okay. Well, press on through and say you
Okay.
you know, you gotta understand, lawyers tell their clients what they need to win. I would say press on through, because landlords, if they're smart, are really terrified of these laws, and more terrified of the fact that the media is going to be out there with a mobile unit filming you being mean to somebody and their dog. Well, that's not right, but the emotionality of this whole thing, and I've often seen landlords back down completely. So if I were representing the tenant, I tell them, let's press on. At the point the landlord refuses, the Tenants Council of Austin is one of the most aggressive advocates of no charge for tenants of any group I've ever seen. Now, with that said, the Fowler firm, and John Leone in particular, mostly are representing property owners. We don't take residential tenants. So.
But don't they have to present a certificate from their doctor stating that they need an emotional support?
You cannot ask those questions. Those are, you know, to go into public service, to a public accommodation, or to go into a facility, you as the landlord or the property manager cannot ask those questions. But let me do this, because we could sit here another hour talking about all the tiny changes. You know, you get, why don't we do, as part of our outreach, the Big 10 on service animals? Are we all right now? Because I think what everybody needs to be knowing is this is in a state of change. And there are bills pending. Now, you know, it's too late to file any more bills in the Texas legislature. You can file amendments on the floor in committee. But that's where we need to be looking to see if it's going anywhere. But I would not.
My question is, I recently had this situation and the tenant said, okay, because my dog is an emotional support animal, I do not have to pay a pet deposit. So I said, okay, do you have any documentation to that effect? And she did send me a certificate.
But there's that, which has to do with deposits. And then there's the issue of, can you say no altogether to the presence of the dog? But here's what I'd like everybody to do, and John and I will prepare for you the Big 10 on service animals, which now thankfully are limited to dogs. No service cats or gerbils or anacondas or horses anymore. We will give you something that is step by step, which we actually, Austin Bar presented on this topic. Our committee was the host, and KXAN sent that. KXAN said they had never had such a response, and everybody thinks they know it, and everybody, in my humble opinion, knows a part of it. So let us give you a complete answer that's right, rather than just address that one point, because tiny changes in the facts in all the service dogs and what the characterization is, including these people who don't know what they are.
We just had our first Google glitch there. Everybody's locked up.
Yeah, disability dogs is much more recent. And there are service dog organizations that are proprietary that are very profitable. And they are making considerable money selling all this service dog paraphernalia. Costumes, dog attire, training, websites, you name it. So, and they are going to be more aggressive to enforce these rules. So let us give you how about 10, thou shalt not. I think that'd be good. In a residential setting, which we need to distinguish that from a public accommodation like a restaurant.
Laura, you can send that to me and I'll make sure that every office gets it.
Yeah, that's good. That's a, you know, I'll give you the update on where the legislature is, because what we've said today, there are some pretty dramatic changes, bills filed, when nobody thinks they're going to go anywhere. But who knows? Who knows this year?
So there was another rabbit hole at the end of this in pertaining to this. It says most landlords are afraid of the damage. If the emotional or service dog damages it, is the tenant responsible?
Oh, absolutely. I mean, that's no different than the tenant themselves. If the dog does damage, if the tenant does damage, if the guest does damage, it's all the same. Dogs don't get a pass just because they're helping a disabled person. That's an excellent question. That's the real fear. You know, most people don't care if a dog's in their facility. They care about damage and injury to other tenants. And there is no exclusion whatsoever for a service dog that creates damage or injury to others.
Thank you. Anybody else questions? All right, guys. Thank you so much, John and Laura. That was fabulous information. We enjoyed having you.
Well, thank you. I want everybody to know Beth has endured several barrages of all our attempts, because we've gotten pretty capable on Zoom, but Google, which Beth has mastered completely, is much more difficult. It has a lot better features. You're beautifully pixelated today, everybody. And the audio was excellent. So thank you, Beth, for guiding us through this.
Thank you. We had a wonderful turnout. I think it was like 130, and there was probably 25 or more on the live stream. So we had quite a few. It's wonderful. Thank you.
Good.
All right, guys, bye-bye. You guys have a wonderful day.
Thank you.
Thank you.